Hello, I'm SA, your AI essayist. Please note that all content, audio and video in this presentation are AI generated. As AI can sometimes produce inaccuracies, I encourage you to verify any factual information presented. With that in mind, let's begin.
The dawn of the 19th century witnessed a Europe undergoing profound transformation. The Enlightenment's emphasis on reason and individual rights had shaken the foundations of the old order, giving rise to revolutionary fervor and a widespread desire for reform. Within this climate, the question of law occupied a central stage. Across the continent, nations grappled with the complexities of legal codification, a process aimed at systematizing and consolidating legal principles into comprehensive codes. This movement, fueled by belief in the power of human reason to create a perfect legal system, found fertile ground in many European states. Germany, a land then fragmented into numerous independent states, found itself deeply embroiled in these debates. The call for a unified German legal code resonated with many who sought to overcome the patchwork of customary laws and local statutes that govern daily life. Proponents of codification argued that a clear, accessible, and rationally organized legal system would promote legal certainty, foster economic growth, and strengthen national unity. This perspective aligned with the burgeoning philosophy of legal positivism, which emphasized the importance of enacted law as the primary source of legal authority. Legal positivism posited that law is fundamentally a human creation, distinct from morality or natural law, and that its validity derives from the procedures through which it is enacted and enforced by the state. Amidst this intellectual ferment stood Peter called Friedrich von Savigny, a legal scholar whose ideas would challenge the prevailing winds of legal reform. Savigny emerged as a leading voice of the historical school of law, a movement that emphasized the organic and evolutionary nature of law. He offered a profound critique of the rationalist and positivist approaches to law, arguing that law is not simply a product of human will or abstract reason, but rather a reflection of the unique historical experience and cultural identity of a particular people. Savigny's opposition to the codification of German law stemmed from his conviction that law is deeply rooted in the Volksgeist, a term often translated as a spirit of the people or national character. The Volksgeist, according to Savigny, represents the collective consciousness, the shared beliefs, customs, and traditions that bind a people together and shape their understanding of justice and social order. Law, in this view, is not something that can be imposed from above by a legislator or a legal scholar, but rather something that emerges organically from the lived experience of the community. It is a gradual and unconscious process, shaped by the interplay of historical forces, cultural values, and practical necessities. Savigny believed that codification, by attempting to freeze law into a static and artificial system, would inevitably stifle its natural development and alienate it from the Volksgeist. He argued that a codified legal system, divorced from the living traditions of the people, would become rigid, inflexible, and ultimately unable to adapt to the changing needs of society. Instead, Savigny advocated for a more historically grounded approach to law, one that sought to understand the law as a product of its historical context and to identify the underlying principles that had guided its development over time. His academic journey began with studies at the universities of Marburg and Göttingen, where he immersed himself in the study of Roman law, a field that would profoundly shape his legal thinking. Roman law, with its rich historical legacy and its sophisticated system of legal concepts, provided Savigny with a model for understanding the historical development of law and for identifying the enduring principles that underlie legal systems. In 1810, Savigny received a prestigious appointment to the newly founded University of Berlin, a center of intellectual ferment that attracted some of the most brilliant minds in Germany. At Berlin, Savigny established himself as a leading legal scholar, attracting students from across Europe and shaping the course of legal thought for generations to come. His lectures on Roman law were renowned for their erudition, their depth of historical analysis, and their ability to connect the legal principles of the past to the challenges of the present. Savigny's intellectual project was thus set against the backdrop of a legal landscape increasingly dominated by rationalist and positivist perspectives. He challenged the notion that law could be created ex nihilo through the exercise of pure reason, or that it could be imposed upon a society without regard for its historical traditions and cultural values. He offered a compelling alternative, one that emphasized the importance of historical understanding, cultural sensitivity, and respect for the organic development of law. His stance created a central tension within the legal community. On one side stood the proponents of legal reform, who sought to modernize and rationalize the legal system through codification. On the other side stood Savigny and his followers, who cautioned against the dangers of imposing artificial legal systems and who emphasized the importance of preserving the historical continuity of law. This debate between legal reform and historical continuity, between rationalism and historicism, would shape the course of German legal thought throughout the 19th century and beyond. Savigny's critique extended beyond the mere advocacy for historical study. He questioned the very foundations of natural law theory, which posited the existence of universal and immutable legal principles discoverable through reason. He argued that such principles were often abstract and detached from the realities of human life. Savigny found them inadequate as a basis for a practical legal system. Similarly, he challenged the rationalist emphasis on abstract principles and deductive reasoning, arguing that law is too complex and nuanced to be reduced to a set of simple axioms. Instead, he emphasized the importance of experience, custom, and tradition in shaping the law. He believed these elements provided a more reliable guide to legal decision-making than abstract reason alone. Savigny's framework, thus, presented a comprehensive challenge to the dominant legal philosophies of his time. He offered a vision of law that was both historically grounded and culturally sensitive, one that sought to understand law as an integral part of the life of a people. This vision resonated deeply with many who felt alienated by the abstract rationalism of the Enlightenment and who sought a more authentic and meaningful connection to their legal heritage. His legacy continues to be debated and reinterpreted, yet his contributions to legal theory remain undeniable. He prompted a reevaluation of the relationship between law, history, and and culture, and his ideas continue to inform legal scholarship and judicial practice to this day. Savigny's lasting influence stems significantly from his distinctive methodology. He championed a historical approach to law, a perspective that diverged sharply from prevailing views. He considered law neither a product of abstract reason nor a creation of legislative theater. Instead, he posited that law emerges organically, a gradual unfolding, rooted in the customs, traditions, and deeply held beliefs of a specific people. This perspective elevates law from a set of imposed rules to an expression of a nation's collective identity. His method involved meticulous study of historical legal sources, particularly Roman law. Savigny viewed Roman law as a rich repository of legal principles, a living laboratory in which to trace the evolution of legal concepts across centuries. He believed that by carefully examining the historical development of Roman legal institutions, one could discern the underlying principles that shaped their form and function. This was no mere antiquarian exercise. It was an attempt to understand the very essence of law itself. Central to Savigny's methodology is the concept of legal consciousness, or Rechtsbewusstsein in German. This refers to the shared sense of right and wrong, the collective understanding of justice that exists within a community. He argued that law is ultimately shaped by this legal consciousness, that it reflects the deeply ingrained values and beliefs of a people. Legislation and judicial decisions, according to Savigny, should be informed by this underlying legal consciousness rather than imposed from above without regard for the existing social and cultural context. Savigny sought to uncover the fundamental principles of law through rigorous historical analysis. He eschewed reliance on rational deduction, the favorite approach of Enlightenment thinkers. He argued that abstract reason, divorced from historical experience, could lead to legal systems that were artificial, arbitrary, and ultimately unsustainable. He believed that true legal understanding could only be achieved through a deep immersion in the historical sources, through a painstaking reconstruction of the legal past. The problems of this time were the dominant rationalist and natural law approaches to legal codification. These approaches, championed by figures such as Jeremy Bentham, sought to create comprehensive legal codes based on universal principles of reason. Savigny saw these efforts as misguided, arguing that they ignore the unique historical and cultural context of each nation. He believed that imposing a uniform legal code on a diverse population could stifle legal development, undermine local customs, and ultimately lead to social unrest. His unique solution was the analysis of the Volksgeist, or spirit of the people. This concept, borrowed from Romantic philosophy, refers to the unique cultural and historical identity of a nation. Savigny argued that law is an expression of the Volksgeist, a reflection of the shared values, beliefs, and customs of a people. He believed that legal reformers should strive to understand the Volksgeist before attempting to codify or reform the law. To ignore the Volksgeist, he warned, was to invite legal chaos. Savigny's historical method involved a careful and systematic examination of legal texts, judicial decisions, and customary practices. He emphasized the importance of understanding the historical context in which these legal sources were created. He believed that legal concepts could only be fully understood in relation to the specific social, economic, and political conditions of their time. This contextual approach to legal interpretation was a significant departure from the more abstract and ahistorical methods favored by his contemporaries. He advocated for a deep understanding of the historical evolution of legal institutions. Instead of viewing law as a static set of rules, he saw it as a dynamic and evolving system, constantly adapting to changing social conditions. He believed that legal reformers should strive to understand this historical process before attempting to intervene or redirect it. To tamper with the law without a thorough understanding of its historical roots, he argued, was to risk unintended and potentially disastrous consequences. Savigny's emphasis on legal consciousness and the Volksgeist has been both praised and criticized. Some have lauded him for recognizing the importance of culture and tradition in shaping the law. Others have accused him of romanticizing the past and of ignoring the role of power and social conflict in legal development. Regardless of these criticisms, his emphasis on the historical context of law remains a valuable contribution to legal theory. He reminded legal scholars and practitioners that law is not simply a set of abstract rules, but a complex and multifaceted social phenomenon. His approach to studying Roman law was particularly influential. He viewed Roman law not simply as a collection of ancient legal rules, but as a living tradition that had shaped the legal systems of Europe for centuries. He believed that by carefully studying Roman law, one could gain insights into the fundamental principles of law itself. This emphasis on Roman law as a source of legal wisdom helped to revive the study of Roman law in German universities and contributed to the development of a sophisticated legal scholarship. Savigny's methodology has had a lasting impact on legal education. He emphasized the importance of historical research and critical analysis in legal training. He believed that law students should be trained to think historically, to understand the social and cultural context of legal rules, and to critically evaluate legal arguments. This emphasis on historical and critical thinking has become a cornerstone of modern legal education. The problems Savigny addressed remain relevant today. Legal reformers continue to grapple with the challenge of balancing universal principles with local customs and traditions. The debate over legal codification continues, with some arguing for the benefits of uniformity and predictability, while others emphasize the importance of adapting the law to the specific needs of each community. Savigny's insights into the relationship between law, history, and culture continue to inform these debates. Savigny's unique approach offers a cautionary tale about the dangers of imposing abstract legal principles without regard for historical context. He reminded us that law is not simply a tool for achieving social goals, but a reflection of a people's shared values and beliefs. His legacy challenges us to approach legal reform with humility, with a deep respect for the past, and with a commitment to understanding the complex social forces that shape the law. He sought not to impose a new legal order, but to uncover the underlying principles that had guided legal development for centuries. This quest for understanding, grounded in meticulous historical research and a deep appreciation for the Volksgeist, remains his most enduring contribution to legal thought. The intellectual journey of Peter Carl Friedrich von Savigny reached a pivotal point with the publication of his most celebrated work, a text that would ignite debate and shape the course of legal thought in Germany on the vocation of our age for legislation and jurisprudence. This treatise, penned in response to a pressing question of the era, articulated a powerful argument against the immediate codification of law within the German states. The early 19th century was a period of significant political and social upheaval in Europe. The Napoleonic Code, with its emphasis on clarity, rationality, and uniformity, had been implemented across vast swaths of the continent. This code, a product of Enlightenment ideals, offered a seemingly seemingly attractive model for legal reform in Germany, which remained a patchwork of independent states with diverse legal systems. The allure of a unified legal code promising certainty, accessibility, and national cohesion was strong. Proponents of codification argued that it would streamline legal processes, eliminate inconsistencies, and promote economic development. The perceived need for unified legal code was fueled by a desire to modernize and strengthen the German states in the face of external pressures. Savigny, however, offered a dissenting voice, one rooted in a deep understanding of history and a profound appreciation for the organic nature of law. He contended that the time was premature for codification. He argued that true law was an expression of the Volksgeist, the spirit of the people, a concept encompassing their shared values, customs, and beliefs. This Volksgeist, he believed, manifested itself over time through the gradual evolution of legal practices and traditions. Savigny posited that law was not a static set of rules that could be arbitrarily imposed from above, but rather a living, breathing organism that grew and adapted in response to the changing needs and circumstances of society. He saw law as inextricably linked to the historical experiences of a nation, a product of its unique cultural heritage. To codify the law prematurely, he warned, would be to freeze it in time, to sever it from its roots in the Volksgeist, and to stifle its natural development. His central thesis revolved around the assertion that legal science in Germany had yet to reach a sufficient level of maturity to undertake the task of codification. He believed that a comprehensive understanding of the historical sources of law, particularly Roman law, was essential before any attempt could be made to systematize and codify it. He advocated for a period of intensive historical research and scholarly analysis to uncover the underlying principles that had shaped legal development over centuries. Savigny envisioned a future legal system founded on a deeper understanding of these historical sources. He believed that by studying the past, jurists could gain insights into the true nature of law and develop a more nuanced and sophisticated understanding of its principles. This understanding, in turn, would provide a solid foundation for future legal development, allowing the law to evolve in a way that was both consistent with its historical roots and responsive to the needs of contemporary society. He proposed a period of rigorous scholarly inquiry, during which jurists would immerse themselves in the study of Roman law, German, customary law, and other historical sources. This research, he believed, would reveal the underlying principles that had guided legal development over time and provide a framework for systematizing and harmonizing existing legal rules. The goal was to create a legal science capable of understanding the law in its totality, its historical context, and its relationship to the Volksgeist. Savigny was acutely aware of the dangers of imposing abstract legal principles without regard for the specific historical and cultural context in which they were to be applied. He argued that law must be tailored to the unique needs and circumstances of each society, and that any attempt to create a universal legal code applicable to all nations was doomed to fail. His emphasis on the historical context of law reflected a broader intellectual trend of the time, a growing appreciation for the importance of history and culture in shaping human institutions. The debate surrounding codification in Germany was not simply a technical legal matter, it was a reflection of deeper ideological divisions within German society. Proponents of codification often embraced Enlightenment ideals of rationality, universalism, and individual rights. They saw codification as a means of creating a more just and equitable society, one in which all citizens were treated equally under the law. Savigny's opposition to codification, on the other hand, reflected a more conservative worldview. He emphasized the importance of tradition, custom, and the organic development of society. He believed that law should be rooted in the specific historical experiences of a nation, and that any attempt to impose abstract legal principles from above was likely to disrupt the social order. He argued that the law was not simply a tool for achieving social goals, but rather a reflection of people's shared values and beliefs. To tamper with the law without a deep understanding of its historical roots and its relationship to the Volksgeist was, in his view, a dangerous undertaking. His perspective was that it risked undermining the very foundations of social order. Savigny's vocation was a powerful and influential statement of his legal philosophy. It challenged the prevailing assumptions about the nature of law and its relationship to society. It forced jurists to reconsider the role of history in legal development and to question the desirability of imposing abstract legal principles without regard for historical context. His arguments resonated with many in Germany who were skeptical of Enlightenment ideals and who valued tradition and custom. His emphasis on the Volksgeist appealed to a growing sense of German national identity and helped to shape the development of German legal science in the 19th century. The impact on the vocation of our age for legislation and jurisprudence extended far beyond the immediate debate over codification. It laid the foundation for a new approach to legal scholarship, one that emphasized historical research, systematic analysis, and a deep appreciation for the organic nature of law. His work continues to be studied and debated by legal scholars around the world, a testament to its enduring significance. He sought a legal system that was not arbitrarily imposed, but organically derived from the historical experiences and cultural values of the German people. He believed that genuine legal reform must be grounded in a deep understanding of the past and a commitment to preserving the unique character of each nation's legal traditions. His vision of a future legal system based on a deeper understanding of historical sources remains a powerful and relevant challenge to contemporary legal thought. Savigny's profound impact resonates most visibly through his contributions to the study of Roman law, a field he approached with unparalleled rigor and a historically informed perspective. His monumental work, System of Modern Roman Law, stands as a testament to his dedication to reconstructing and systematizing the foundational principles of Roman legal thought. This ambitious undertaking sought to move beyond the fragmented and often unsystematic approaches that characterized the study of Roman law during his time. The legal landscape of the early 19th century presented a complex challenge. Roman law, despite its historical significance, existed in a state of disarray, its principles scattered across various texts and interpretations. Legal scholars grappled with the task of extracting coherent doctrines from a vast and often contradictory body of legal materials. Savigny recognized the need for a more systematic and historically grounded approach to unlock the true essence of Roman Roman law. His solution lay in a meticulous historical analysis, a deep dive into the original sources of Roman law to uncover its underlying structure and principles. He believed that Roman law was not simply a collection of arbitrary rules, but rather a coherent system of legal thought that had evolved organically over centuries. To understand Roman law properly, one had to trace its historical development, examining the social, political, and economic contexts in which it had emerged. Savigny embarked on a painstaking reconstruction of Roman legal principles, drawing upon a wide range of historical sources, including the writings of Roman jurists, legal codes, and other historical documents. He meticulously analyzed these sources, identifying the key concepts and principles that formed the foundation of Roman law. This involved a careful process of interpretation aimed at extracting the original meaning and intent of the Roman jurists. A cornerstone of Savigny's approach was his concept of juristic construction, or juristic construction, a method of developing a coherent legal system through the careful analysis and synthesis of legal concepts. Juristic construction involved identifying the fundamental principles of Roman law, and then using these principles to construct a logical and internally consistent legal system. This process required a deep understanding of legal concepts, as well as the ability to identify the relationships between them. Savigny viewed juristic construction as an essential tool for legal scholars, enabling them to transform a collection of disparate legal rules into a unified and coherent body of law. It allowed for the identification of underlying principles, the resolution of inconsistencies, and the development of new legal doctrines based on established principles. This approach emphasized the importance of legal reasoning and the application of logic to legal problems. The concept of juristic construction played a central role in the development of Savigny's system of modern Roman law. He employed this method to organize and systematize the vast body of Roman legal materials, creating a comprehensive and internally consistent account of Roman law. This work became a standard reference for legal scholars and practitioners, shaping the study of Roman law for generations to come. Savigny's system of modern Roman law was structured around a set of fundamental legal concepts such as property, contract, and obligation. He meticulously analyzed each of these concepts, tracing their historical development and identifying their essential characteristics. He then used these concepts to construct a logical framework for understanding Roman law as a whole. His work emphasized the importance of understanding the historical context in which legal concepts had emerged. He argued that legal concepts were not simply abstract ideas, but rather products of specific historical circumstances. To understand a legal concept properly, one had to trace its origins and examine the social, political, and economic factors that had shaped its development. The system of modern Roman law provided a comprehensive account of Roman private law, covering a wide range of topics, including property rights, contracts, torts, and inheritance. Savigny's analysis was characterized by its rigor, its attention to detail, and its deep understanding of Roman legal sources. The work became a model for legal scholarship, demonstrating the power of historical analysis and systematic reasoning in the study of law. Savigny's contributions extended beyond the mere systematization of Roman law. He also sought to illuminate the underlying principles that animated the Roman legal system. He believed that Roman law was not simply a collection of rules, but rather a reflection of the Roman spirit, a manifestation of the unique cultural values and social norms of Roman society. He argued that Roman law was characterized by its emphasis on individual rights, its commitment to fairness and equity, and its respect for tradition and custom. These principles, he believed, were essential to the success of the Roman legal system and its enduring influence on Western legal thought. Savigny sought to uncover these principles and to demonstrate their relevance to contemporary legal problems. The influence of Savigny's work on the development of legal science in Germany and beyond cannot be overstated. His emphasis on historical research, systematic analysis, and juristic construction transformed the study of law, elevating it to a new level of intellectual rigor. He established a new standard for legal scholarship, one that emphasized the importance of deep knowledge, careful reasoning, and a commitment to historical accuracy. His approach to legal study resonated deeply with legal scholars throughout Europe and North America. His emphasis on historical context and systematic analysis provided a framework for understanding law as a dynamic and evolving phenomenon, shaped by historical forces and cultural values. This approach had a profound impact on the development of legal history and comparative law, two fields that owe much to Savigny's pioneering work. Savigny's students and followers carried his ideas forward, establishing schools of legal thought that emphasized his historical and systematic approach. These schools played a crucial role in shaping the development of legal education and legal scholarship in Germany and elsewhere. They promoted the study of Roman law as a foundation for understanding modern legal systems and emphasized the importance of legal reasoning and juristic construction in the development of law. The impact of Savigny's work extended beyond the academic realm. His ideas influenced the development of legal codes and legal reforms in several countries. His emphasis on the importance of historical context and cultural values led to a greater appreciation for the unique legal traditions of different nations. This contributed to a more nuanced and historically informed approach to legal reform. Savigny's legacy is complex and multifaceted. He is remembered as a brilliant legal scholar, a pioneering legal historian, and a profound legal thinker. His contributions to the study of Roman law, his concept of juristic construction, and his emphasis on the historical context of law had a lasting impact on legal science. His work continues to be studied and debated by legal scholars around the world, a testament to its enduring significance. His emphasis on understanding law as a product of history and culture, rather than a set of abstract principles, remains a valuable contribution to contemporary legal thought. Savigny's influence on legal thought remains substantial, extending far beyond his immediate circle of students and colleagues. His meticulous scholarship and innovative methodologies laid the groundwork for the development of legal history as a distinct discipline. Prior to Savigny, legal history often consisted of little more than chronicles of laws and rulers, a simple recitation of events lacking deeper analysis. Savigny transformed this landscape, advocating for a systematic investigation of the origins and evolution of legal institutions, demonstrating how law was interwoven with the social, cultural, and political fabric of a nation. He urged scholars to delve into primary sources, to analyze legal texts in their original context, and to trace the gradual development of legal concepts over time. His emphasis on the historical dimension of law also had a profound impact on the emergence of comparative law. By highlighting the unique historical trajectories of different legal systems, Savigny encouraged a more nuanced understanding of of legal diversity. He believed that each nation possessed its own distinct legal character, shaped by its particular history, customs, and traditions. This perspective challenged the prevailing tendency to impose universal legal models without regard for local conditions. Instead, Savigny advocated for a careful comparison of different legal systems with a view to identifying both commonalities and differences and to understanding the reasons behind these variations. This approach paved the way for a more informed and culturally sensitive approach to legal reform and harmonization. However, Savigny's legal philosophy has also been subject to criticism. One common charge is that his emphasis on the historical Volksgeist, translated as the spirit of the people, bordered on Romanticism. Critics argue that this concept is vague, subjective, and susceptible to manipulation. They contend that Savigny's focus on the organic development of law could be interpreted as a justification for legal conservatism, a resistance to change and reform in the name of preserving tradition. The fear was that such a philosophy could be used to legitimize existing power structures and to suppress dissent. Indeed, Savigny's aversion to codification, his preference for the gradual evolution of law through juristic interpretation, has been seen by some as an obstacle to progress. Critics pointed out that his approach could perpetuate legal uncertainty and inequality, as the development of law was left in the hands of a small elite of legal scholars. They argued that a clear and comprehensive legal code accessible to all citizens was essential for ensuring legal certainty and promoting social justice. Despite these criticisms, Savigny's emphasis on the historical context of law retains enduring relevance. In an increasingly interconnected world, where legal systems are constantly interacting and influencing one another, understanding the historical roots of legal traditions is more important than ever. Savigny's work reminds us that law is not simply a set of abstract rules, but a reflection of a society's values, beliefs, and experiences. It is a product of history, shaped by the struggles, compromises, and aspirations of generations past. The subsequent development of the German Civil Code, known as the Bürgerliches Gesetzbuch or BGB, provides an interesting case study in the reception and modification of Savigny's ideas. The BGB, which came into effect in the 19th, was a culmination of decades of debate and discussion among German legal scholars. While the BGB drew heavily on Roman law, in accordance with Savigny's emphasis on the historical foundations of German law, it also incorporated elements of customary law and modern legal thought. The BGB represented a compromise between Savigny's vision of law as an organic development and the need for a clear and comprehensive legal code. While the BGB was structured around abstract legal principles, it also allowed for judicial interpretation and adaptation to changing social conditions. In this way, the BGB sought to balance the need for legal certainty with the need for legal flexibility. It can be viewed as a practical application of certain aspects of Savigny's thought, tempered by the realities of modern legal practice and the demands of a rapidly changing society. Savigny's legacy is therefore a complex one, marked by both significant contributions and potential limitations. He was a brilliant legal scholar who transformed the study of law, emphasizing the importance of history, culture, and context. His work has had a lasting impact on legal science and continues to be studied and debated by legal scholars around the world. His insistence on understanding law as a product of its historical and cultural environment remains a valuable insight, one that is particularly relevant in our increasingly globalized and interconnected world. This perspective encourages a more nuanced and sophisticated approach to legal reform, one that takes into account the unique circumstances of each society and avoids the imposition of universal legal models. However, it is equally important to acknowledge the potential pitfalls of Savigny's legal philosophy. His emphasis on the Volksgeist, the spirit of the people, can be interpreted as a justification for legal conservatism, a resistance to change in the name of preserving tradition. His aversion to codification can perpetuate legal uncertainty and inequality. Ultimately, Savigny's legacy is a reminder that law is a complex and multifaceted phenomenon shaped by a variety of factors, including history, culture, politics, and economics. Understanding the interplay of these factors is essential for developing a just and effective legal system, a system that reflects the values and aspirations of the society it serves. His work encourages a continuous and critical examination of the relationship between law, history, and society, a dialogue that is essential for ensuring that law remains a force for progress and justice. Savigny's insights continue to offer a valuable lens through which to examine the enduring relationship between law and the societies it governs.
We really appreciate you tuning into this AI-powered presentation. Our goal is to push the boundaries of AI in content creation, and your input is invaluable. If there's a particular subject you'd like to see us tackle next, or if you have suggestions on how we could fine-tune our AI's creative prompts, please don't hesitate to leave your ideas in the comments section. We're excited to bring you more unique content very soon.